I've been tasked to talk about 5 major areas: establishment and services of SIMC and mediation in Singapore, case management, statistics, structural process, legislation, and case studies. So I will go straight into it. Mediation, IP mediation in Singapore, of course, is very critical, and it is led by IPOS, the Intellectual Property Office of Singapore. And the whole idea of IPOS is really to manage all the IP disputes, registration, etc. And this dispute resolution forms part of their mandate. You can request for an IPOS mediation at any time before the outcome of the cases as the cases get heard. And at SIMC, we're very privileged to be one of the mediation providers for IPOS mediations. We have another organization called the SMC, Singapore Mediation Centre, which does a lot of domestic mediation. We do more of the international mediation. I'll talk more about that in a little while. But the idea here is to choose mediation as an alternative to a hearing, because we think it's a better resolution. And IPOS also very generously provide funding to defray some of the mediation-related costs, regardless of the outcome. So they are very good. They organize it and they fund it as well. So here at SIMC, we are a not-for-profit organization. We specialize in cross-border commercial disputes. A lot of them are quite complex, and IP certainly is one area that we focus on. We are just launched in 2014, so we are a relatively young organization, 6 years old. Launched by our Chief Justice, Sundaresh Menon, and our Minister of Law, Mr. K. Shanmugam. We have an international panel of 69 mediators across 17 countries or so. And in addition, we also have specialist mediators who are specialists in IP, specialized in construction, specialized in shipping, etc. But IP is certainly one of the areas that we are specialized in, and we are happy to talk about that in a little while with some of the cases. So what is SIMC, right? What is the Singapore International Mediation? So we have basically 4 mandates. One is case management. We case manage mediations, and my colleagues have talked about conciliation, neutral evaluation. We do that as well. We bring parties together. We help the mediator. We organize it. We do the pre-mediation. We do the post-mediation, the entire end-to-end process. We do training as well, like Lewin has mentioned, and Alexandra as well. We do training across different countries, and I'll talk about that in a little bit. We promote mediation across, within Singapore with the businesses and in many key countries, which I will elaborate a little further. And then we talk about thought leadership. We're very keen to see how we can push mediation to the next level, because it is still relatively new, especially cross-border commercial mediation. And we write, we speak like in a place like that, in a platform like that, and we engage both with the commercial as well as the government. So I love this photograph because I know a few of you are represented here, and I noticed earlier with special focus on Cambodia, Laos, and Myanmar. And you can see that I'm there, right? I was there in 2019 before COVID hit us. And I had the real privilege of meeting both judges, the Attorney General's office, mediators, lawyers, you name it, right? On 3 different occasions where we traveled to your beautiful countries and talk about mediation and how we can collaborate. I certainly hope to do more of this once we can travel again. And we are very pleased that we receive very good feedback, and we continue to work with each of these countries and others as well as we promote mediation. Because of COVID, we have switched more to online seminars like this one. So this is just 2 examples of the seminars webinars that we have done. One was basically with a law firm, Withers Carter Wong, where we talk about mediation and arbitration in ASEAN. And then we also have the other one, which is really, again, organized by the Thailand Arbitration Centre. We're very blessed to be part of that. and we talk about the multi-tiered dispute resolution clause. So this goes on regardless of whether there's COVID, and we continue to stay very active in this. And so if there are opportunities for us to participate in each of your countries' webinars, write to us. We'll be very happy to be involved. And again, IPOS, thank you for inviting us. So some of you talked about online mediation. Of course, we do online mediation as well now with COVID, parties not being able to travel. But I thought I want to show this photograph because this is what we call hybrid mediation. And when we say hybrid, it means we have a combination of online and in person. So this is taken with the consent of all parties, so nobody is disclosed here. But generally, the lawyers who represent the parties may be, if they are in Singapore, they would appear in person. As you can see, everyone wears a mask in this time. There's this divider between the parties. They're all equally spaced out, and we have an in-person discussion. But at the same time, we also have parties calling in from overseas. Whether it's Hong Kong, whether it's Cambodia, whether it's Vietnam, India, etc., they will just call in, and then we'll have a session that's both in person and online. And when we do the breakout session, I think Alexandra talked a little bit about that earlier, where you have a private session, we have that online and in person as well. So it's as seamless as it can be. And for the people who are online, we try to make them as present and as active as possibly we can, as if they are physically there. And I will tell you that as much as online is good and is a wonderful tool, it does make a difference when it is in person. So we try to make the best of both worlds here. Statistics and case management. We are very happy to report that we have seen a very significant increase in the number of cases pre-COVID compared to now. So 2019 will generally be pre-COVID. You see that we're about 23 cases. And in 2020, we almost doubled that, 43. And now, at the end of September, we're already at 59. So you can see that the numbers are growing very quickly. We're about 3 to 4 times what we were pre-COVID. And I think that is because the parties recognize the importance of mediation and how it can be very flexible. And in this time where everybody needs help to resolve issues, mediation has a very powerful way of helping parties to really address their interests, right? What is really important to them, and then very quickly move on to a solution. And our strong belief is that the parties can move quickly into a resolution is better off battling this COVID pandemic compared to others who try to slog it out in court, which may take 2, 3, 4, 5 years. So we're very confident that parties will benefit from the mediation process. I'm moving on to some of the data again on SIMC. Up to date, we have about 200 cases, although we are relatively young, more cases in the recent years than before. The dispute value is very, very high. It's about 5.4 billion. So on average, our cases is about 20+ million US dispute value average. Of course, we have small ones as well, but we have huge ones as well. So when you pull it out as an average, it is high, right? 28 million US is a very high average amount. But at the same time, for IP, we are very focused. And like I said, we do have some relatively smaller amounts. Our settlement rate, I'm very, very pleased to say that we are still at about 70 to 80%. In fact, this year, what I've looked at the latest number, we are above 80%, right? So very, very high settlement rate. And really it goes to the quality of the mediators, the ability and willingness of the parties to come to settlement. And you can see that the number of countries that are represented that comes to SIMC for mediation, they come all over the world, but with really a huge number from Asia itself. We're still very much an Asia-based mediation center based on that those charts, although we do have people from US and UK as well. So structure and process. I won't go too much into this because both our speakers have talked about this, but generally we try to keep it as simple as possible. We start off with pre-mediation. I think Luin talked about that as well. Then after the pre-mediation, which actually is a lot of work, right? Especially when it's online, there's actually a lot more work pre-mediation. You need to prepare the parties, exchange of documents to help them understand what a hybrid process is like, etc. Then we have an exchange of mediation statements. Then we actually have a very exchange of the list of the people attending, which is very important to know who's attending, and we must make sure the right people are there. I think we talk about authority, but at the same time, we don't want too many people attending. You can imagine, especially when it's online nowadays, online, everybody want to take part. You can have 20 people from the other side taking part, but actually only one person's decision is important. So we try to have just the right number of people present for the mediation itself. Then we check to make sure there's authority attending, there's a general preparation itself. Then the next chart, you see at the mediation itself, of course, we have the welcoming, with the opening statements by parties, setting of issues, exploration of issues, very similar to what was discussed earlier, so I won't go into it. Joint session, private sessions, option generation, bargaining, as Alexandra has called it. Then hopefully we will come to a settlement of the agreement itself, whether it's actual signing of the agreement or heads of agreement. Generally, our cases are settled within a day, but we have had cases that are for 5 days as well. So it really depends on the parties. We also have cases where we call it a day, but actually it went on for 26 hours. So I don't know whether you call it a day, but that's the longest that I have attended. I think Alexandra was saying 2 a.m. We started at 9 a.m. and we finished at 11 a.m. the next morning without a break. All right. So that is the longest I've ever been on. The parties felt very tired, and so did I. So but the important thing, it was settled, and everything was signed, and the parties went away very happy with the settlement. I think as long as the parties are willing to go on, we try to accommodate and help them to come to a settlement, because sometimes the opportunity knocks and you just have to grab it. Then the last part, of course, the post-mediation, whether there's a settlement or there isn't a settlement, there's actually some work to be done. Especially when there isn't a settlement, what we try to do is to see if there's other follow-up work to do, whether the parties will want to consider further mediation or some exchange, or maybe some private arrangements that they would come up with. So that's a very simple description of the process. I want to spend a little bit of time about this. I understand my colleagues did not elaborate too much about this, but I think that UP or the arbitration is a very elegant solution to some cases, not all cases, some cases. So sometimes the parties need to start arbitration because you need to get their attention, right? Sometimes mediation is, oh, the other side is not serious. I don't want to get too involved. I don't want to invest too much. But once you start arbitration, the parties start to commit to a dispute resolution process, paying quite a lot of fees, setting up the arbitration tribunal, etc. Then they know, both sides know that they are serious about this. And so UP provides a very elegant way, like I say, between Singapore International Arbitration Centre, SIAC, and SIMC, Singapore International Mediation. So it's a one-stop process where they started at SIAC with arbitration. It gets paused for 8 weeks, and the matter gets referred to SIMC automatically for mediation. And if it's successful, then it's the end of the matter. They can bring it back to SIAC to register the arbitration, and then it gets enforced under the New York Convention as an arbitration award, and therefore it's enforceable. Or if it is not settled, it's only a delay of 8 weeks. It goes back to the arbitration and it continues. So we've seen a large number of cases of UP where very successfully the parties are able to resolve the issue. The success rate is as high as the normal, our usual other cases. So it's about 70 to 80%. And we're able to help parties to very quickly, instead of spending a substantially greater amount of money and time, they had the matter arbitrated, they had the matter resolved under mediation. So this is something that I would highly recommend, especially for those of us who have an arbitration agreement clause in your agreement. Switch it to an up provision, which we have on our website. I think it's a very effective way. And being in-house myself, you heard I was with IBM. This is where I first heard about mediation, because I was a big litigation lawyer before that. I fight everything. But 10 years ago, I first got involved in mediation, and I saw the benefits of mediation and how it's really good for parties to resolve. And this is how we got introduced to mediation. Very quickly on legislation, I'll go through this quickly because I really want to spend a bit more time on the case study, which I think you'll find interesting. So the three legislation I want to talk about in Singapore is really the Mediation Act, which is 2017, the Singapore Convention on Mediation, and then the Convention on Mediation Act 2020. As you can see, they are fairly recent as well. The Singapore Mediation Act, what it basically does, it allows mediated agreements to be enforceable as a court judgment once it's registered with the court. So a mediated agreement is actually just a contract, right? It's just written on a piece of paper. If you want to enforce it, technically you got to go to court, start the whole legal process of suing. So the Mediation Act shortcut the whole process by allowing this mediated agreement, just an agreement, to be registered in the High Court as a court judgment. So it's as good as a court judgment. So this helps the parties to very quickly be able to enforce these mediated agreements in Singapore. It's at least enforceable in Singapore. And of course, if there's a reciprocal arrangement between Singapore and say Vietnam, then that court award can also be enforced in Vietnam. But that depends on the reciprocal arrangement between Singapore and other countries. So that's what it does. It helps parties to register the court order, like I mentioned. But this Singapore Convention is actually interesting because it sidestepped that by allowing parties to sign up to this United Nations Convention because it is initiated by them. And by signing up to this convention, like the New York Convention, the mediated agreement then can be enforced in the country that have signed up. So it is almost a participation on a voluntary basis, right? So if you want your mediated agreement to be enforced in your country, you sign up to this convention. And you can see this in 2019, we had a huge celebration where we had 50 over countries that have signed the mediation agreement, the Singapore Convention. I think I have that in the next, this is the next chart I want to come to. As you can see, it's all over the world now. 55 countries have signed, 7 countries have ratified. And in Southeast Asia alone, you can see there's a lot in Asia, but in Southeast Asia alone, Brunei, Laos, Malaysia, Philippines, Singapore, and I know we have an audience out there who are from these countries. Your countries have signed the convention, they need to ratify, and once it's ratified, the mediated agreement becomes enforceable in each of your countries. So very exciting development that is happening right now. And I'm sure other countries will also be signing up soon. So this is the Singapore Convention on Mediation Act. So what this does is it gives effect to the Singapore Convention. It ratifies it so that now a mediated agreement can be enforced in Singapore. So there are 2 steps. First, you have to sign the convention. Then you have to set up a law within your country and then ratify it. Then it becomes enforceable. So Singapore has done both steps. You can see from the earlier chart, the other 4 countries have not ratified. Only Singapore has done so. And we've done it through the Singapore Convention on Mediation Act, which then now allows these mediated agreements to be enforceable. Here's a lovely picture of our Minister of Law depositing the convention, the ratification itself, which then allows us to be recognized as a country, one of the countries that have ratified the convention, and then the convention came into force on September 2020, so just a year ago. And this was a newspaper report on it. So I will spend the last 9 minutes or so talking about our case studies, right? So the first case study, there are two case studies. I can talk about quite a few, but I just want to highlight two because I think these are really, really interesting. The first is a trademark dispute between the owner of an international lifestyle technology. I cannot tell you what company it is, and I describe it, you will know what it is. You'll say, oh, we make that company. So I don't want you to try to guess, so I kept it quite vague. And a Singapore reseller, that's the first case that we talk about. The second one is an IP dispute, where it's really an app developer, subcontractor, and the dispute with the owners, the users, etc. So let's jump into the first case. So this lifestyle, we have these very famous lifestyle products, unfortunately was pilfered or stolen from an overseas factory. And they were then brought to Singapore and sold online on an e-commerce platform by the reseller. I think all of you who are online will know exactly what I'm talking about. It's really, trademark infringement, sale of unauthorized products, etc., etc. So the losses are in the millions, you can imagine, because for the original trademark owner, this is very valuable IP that they have. So they sued the reseller for breach of trademark. The parties attempted settlement on their own without success, and then they came to SIMC. If you think about a case like that, it's pretty straightforward, right? You breach my IP, I have proof of it, I just sue you, end of the matter. What is there to mediate? Why is there a need for mediation? What does mediation bring that is extra, that's different? What problem can you solve? So in this case itself, we actually explored creative solutions for the parties to try to come to a settlement, right? So what we wanted to do was, first of all, the reseller, you can imagine, being online, may not have a lot of money, right? They are very small. And if you sue them for the full amount, millions of dollars, they will go bankrupt. You're not going to get anything at the end of the day. So that was the thought that the IP owner has. So what do? Okay, you can have a settlement sum, and then you can pay by installments. You can discontinue it. But what was the breakthrough? The breakthrough in this case, and it may not be true in all cases, but in this case that I want to bring up was that the reseller could bring something to the table that is the real interest of the IP owner. What is the real interest of the IP owner? You think about it. The real interest of the IP owner is to know who the manufacturers is overseas, not the reseller downstream, but go after the real manufacturer, who stole those goods, who did the manufacturing, how did that happen, how did the goods get into this reseller's hands, etc. The whole chain of supply the whole supply chain is what they want to know. But if you go to court, the reseller is not going to cooperate with you. You just sue them, they are announced bankrupt, end of the story. But in this case, we were able to get the parties to collaborate on the investigation, and therefore really addressing what the IP owner wants. But in exchange for that, the IP owner agreed to a smaller settlement sum and in installments that the reseller can afford to pay, right? So it's a very good example in this case of how mediation in an IP case can be a better solution. I know the judges won't like me for saying that. It can possibly be a better solution sometimes than just giving an award of damages. Here you get two parties being able to address their real needs and concerns. From the reseller's point of view, they can't afford to pay, they don't want to go bankrupt. From the IP owner's perspective, they want to know who the real culprits are. So we were able to find that resolution. The next case that I have is on, again, a very interesting case. App developer, app owner had a contract to build an online learning platform. I'm sure all of you are very familiar with that. The app developer, like in all collaboration, engaged a subcontractor to run the project. Unfortunately, like in all businesses, there's a dispute between the app developer and its subcontractor. So it has nothing to do with the owner, right? There's a problem with that. And in many of these solutions nowadays, being very complex, you do have several subcontractors. So this resulted in the failing of the support services that affects the owner. The owner said, it's not my problem. App developer, settle this, right? It's affecting all my users. I have thousands of users. So there's a problem, right? So it went to court, there's a proceeding, then they agreed to mediate SIMC. So what made difference here? So here, there were thousands of app users who were using it. They were concerned that if they do not solve this problem quickly, the whole app will fail. And as you know, time is of essence in IP. Time is of essence. You have to resolve those issues very quickly. And if you don't, people will start using another app. So in this case, we were able to canvass the interests of all the parties. We have an agreement on payment amongst the three, because again, the subcontractor want to be assured of some payment, and the owner might divert some of that payment directly to the subcontractor. But what's very important is that fourth bullet point there, the app is now transferred to another third party whose reliability is acceptable to the owner. So he doesn't have to rely on this app developer nor the subcontractor. So he managed to get the release of all the IP, all the code lines, source codes, etc. Put it to a third party so that the app can continue then the two of them continue to their fight until I don't know where. But that's the arrangement that was made. Again, this solution would be difficult in a litigation case because it involves a completely different third party that will take over the app. But in this case, even amongst the three of them, after they've settled it, it was moved to a fourth party, another party who look after the app from them. So again, a very neat, very clever, very elegant solution to a very difficult problem. And this was only possible through mediation. So I thought these two cases are very interesting, which you might find useful, and why mediation it can be better. Not in all cases, but in these two cases they are. So on that basis, let me say thank you to all of you for your patience. And I think I've just come up to my 30 minutes.
Yes, thank you very much, Mr. Chuan, for your very interesting presentation, sharing with us the operation, practice, and two very interesting case studies as the SIMC. So now we will move to the Q&A session of our workshop today. I would like to invite all of our speakers today, Ms. Alessandra, Ms. Natalia, Mr. Lewin, and Mr. Weeman, if you could have to choose the Q&A session. We also open the floor for the audience now. If you have any questions for our speakers, you can either raise your hand and direct your questions directly to our speakers, or you can type your questions in the chat box. I think while waiting for the questions from the audience, I would like to have a few questions for our distinguished speakers, if you allow. I think one of the questions that we received from one participant in the audience is that, as Alessandra shared in your presentation yesterday, that mediators are also human and can make mistakes. So in your point of view, what are the common mistakes that mediators make and how to avoid them? I would like to invite Alessandra to answer this question, and I also would like to invite Weemin and Lewin to try to contribute and share your view as you see fit. Thank you.
Thank you very much for that first very delicate question. Well, it's not delicate, really. There are many questions that we can make, obvious mistakes that we can make as human beings. What I would think here, what is difficult, I mentioned it yesterday, is to remain impartial sometimes. That we do not take, part because we find that one party is actually being much nicer than the other one. I think I shared with you yesterday, I had one occasion with a party that was being very difficult and almost disrespectful towards the mediators. And there sometimes, especially when the day gets long and you can lose patience, but obviously you try not to. So that would be one mistake. Another thing that mediators need to do, so it would be a mistake not to do it, is keep the momentum, keep the energy flowing during the mediation day. And this is also sometimes difficult, which is why we at EU IPO very much favor co-mediation, because we can then help each other when one of the mediators loses this energy, then maybe this mediator goes and grabs a Snicker bars and goes back while the other one continues. And then we also have time to exchange, also to release a bit of frustration with the co-mediator. So losing this momentum, I think, would be another thing that comes to my mind right now. I'm sure my colleagues will have other mistakes done or to avoid.
Yes, thank you, Alessandra. Just would like to check if Natalia, Lewin, and Weeman, if you would like to contribute or share anything.
Something that is linked to the, if I may, something that is linked to the legal background that, or the practice as lawyers background that a lot of mediators may have, is that sometimes we tend to ask, we do not ask open questions, and as it should be, because we would like to obtain a yes or no answer, because we are trained like this. We are trained to do that, being lawyers and litigators. So I think this type of we need to change our scope when we enter into mediator and think as mediators and leave our litigator hat on the side, because by asking closed questions and not open questions, and when the questions just has to be answered by a yes or no, in that case we just do not give the necessary space in order to go through the exploration and to open discussions and to find common ground, as we said.
Yeah, I'd like to follow up on that. I think that being a lawyer, sometimes like Natalia said, you have to put your hat as a lawyer outside of the mediation room. Because as lawyers, we are very good at giving advice. You should do this, you should do that. And we are very good at what I call allocation of rights, right? So we have a bunch of rights. The lawyer look at it and say, okay, with this bunch of rights, you should get this part, you should get this part. So allocation of the rights is what we're trained to do. Now, for mediation, it's not just about allocation of rights. It's about creating more out of that rights to create a bigger table, a bigger pie. And you can only do that when you are humble enough not to give the answer and think that you have the solution, but to ask the parties, like Natalia said, open question as to what is important to them. Why do they do that? Why did they come to this dispute? And then it's with that, then you can create a much bigger solution for everybody. And as lawyers, we should stop giving advice and let the parties come up with a solution themselves, of course, with guidance and with proper questions, etc. But at the end of the day, we do need to step back.
I think one of the traits of a good mediator is to be tenacious. It's not in a way that it's not obvious to the parties. We have I think one of our successful mediators is when the parties tell you that they are no longer they are terminating the mediation. The parties must process that line of thinking. Maybe they are not terminating the procedure because they are into impasse. So it's the function of the mediator to provide options, to see to it that the parties are really have thought of all the interests and the things that they need. Maybe based on my experience, when the parties are into that impasse, then it's really at the point that they are into something that they are nearing the settlement of the case. So it's really it's the work of the mediator to see to it that he process all these things. So it's really the one of the traits of the mediator to see to it that all these things are known to the parties.
Yes, thank you very much, Mr. Lewin and all the speakers for your answers and contribution. I think I saw hand raised from some of the audience. I think we just saw the raised hand from our colleagues from Malaysia. So if you have questions, please go ahead.
I just want to ask one question. If there is a dispute among the IP owners, will it, is it possible for them to, let's say, to have it, if it's possible to have it after they have gone to the court to settle the disagreement, is it possible for them to come back and do this settlement arbitration with the mediation? Thank you.
Yes, I think for these questions, maybe I will invite Alexandra and Natalia to start first, and we can hear the view from women and Lewin later.
Maybe can you please repeat the question just to make sure that I understood correctly? So when you've done mediation, if you can go back.
Yeah, let's say we it's not that they go to the mediation first. It's just that they went to the court and they are not satisfied with the result from the court's order. Can they go back to you to mediate? Thank you.
Okay, thank you very much for this question. At EU IPO, there must be an appeal pending. So the answer that we will give you will maybe be different to what our colleagues will give you, because at EU IPO, once the appeal is concluded, if there is no other appeal pending, as things are right now, it is not possible to go to mediation. There has to be an appeal pending. So this is our situation right now. If maybe parties have mediated before and then there is a decision by the appeal because they haven't reached an agreement, we would see. I'm not aware of this happening yet. So in principle, there has to be an appeal pending.
Yes, just to complement what Alexandra said, as we explained, there is this in order for the parties to have this service before the boards, there should be an ongoing appeal proceedings before the EU IPO. This is the case, with the exceptional case of SMEs that I mentioned, but also in that case there should be proceedings before first instance of EU. So there's always should be a link, let's say, to our proceedings. So it's true that the other colleagues may have different answers than ours, Alexandra.
So maybe I will chime in. For us, mediation is a voluntary basis, right? So both sides have to agree before you can have a mediation. Most of the cases are before you go to court or in the middle of a court before you get an award one way or the other. That's most of the cases. We do have some cases where the court has decided and it's on appeal, like Alexandra has said, and one side felt that, hey, I may be able to get a better deal. Even though I won the first round, I may get a deal that I can agree with on settlement. So after you get an award, usually the party that won would not want to settle because they say, I've already won, right, the first round. So we do have a few cases where it was settled after the award, but we have not had a situation where after the appeal, they still want to settle. I don't think the side who won the appeal will want to settle the case.
I think I agree with that. I think if you look at our procedure, appeal cases from the Office of the Director General is also referred to mediation. But if you look at the success rate, given that they already have they have won on the lower stage, then we have a low rate of success in terms of appeal cases. But I agree that in our experiences, some of this, when the parties undergo mediation, they may not have settled in the lower, in the Bureau of Legal Affairs, but when they go to the appellate court, then they see the benefits of maybe we should just go back to our earlier negotiation, and since they already have a draft agreement or something which they could talk to, then the parties eventually agreed or eventually settled the case, even at some point during the litigation process. So we have several cases that the lawyers go back to us and tell us that eventually we have decided to renegotiate, and at the same time we have entered into a compromise agreement given what we have talked during the IPO stage. So the benefits of mediation is that you see the interest of the other party. So this gives you a broad perspective wherein even at the level of appellate court and up to the higher courts, the parties are really they have talked with each other. Then they have this relationship, whatever at whatever stage, then they could decide to renegotiate and at the same time go ahead with the compromise agreement. So it also a good benefit for mediation. It's one of the benefits.
Yes, thank you very much to all of our speakers. We received 2 to 3 questions in the chat box, and I would like to ask our speakers as well. On average, how long the mediation process will take from preparation to conclusion and decision? For this, I would like to ask one by one speakers if you could have to share the practice in your office. Maybe we can start first with EU IPO.
I don't know if we have statistics on this, so it depends obviously on the parties, how willing the parties are to cooperate and how able the mediator is to keep tenacious and see. So the actual preparation shouldn't take long. We will give a deadline to the parties to firstly sign the mediation agreement and then provide us with the written summary of the case. And therefore, we usually give, depending on also the time of the year and everything, we would give a couple of weeks for the summary, a couple of weeks to the mediation agreement, and then the preparation. Ideally, we do not have a deadline as our colleagues from Philippines of 90 days. It's not bad. So ideally, the actual mediation day takes only 1 day, and then the preparation would not be longer than these 90 days, but sometimes it is protracted in time.
Thank you, Alessandra. Yes, how about SIMC?
Yeah, so the fastest that we've come to a mediation agreement is within a week, because the parties really needed a solution very quickly, and they needed a particular resolution. So we were able to pull together mediation within a week. But that's really exceptional. I would say on average, it would take anything from 3 to 4 weeks would be the normal time. And again, it really depends on whether you want 2 days, 3 days. And if it's 3 days, sometimes they break it up over 2 or 3 weeks so that the parties can digest the information and seek approvals, etc.
Yes, thank you, Mr. Chuan. Yes. Yes,
Yeah.
Mr. Lupin, please go ahead.
Yeah.
Yes.
It depends on the parties. I would say it depends on the parties and how they would be willing to compromise or settle the case. In IPO field, we have based on our experience, we have cases which were settled in just 1 session, but we also have cases which takes because in IPO field we have a 90-day mediation period, but they could extend it with a maximum of 1 year. I think that That's the maximum, because when you look at our cases, these are related to opposition of cases, and there's most of these are local applicants and local companies. So we give as much as time they want to really negotiate and settle the case. So it depends on the parties really.
Yes, thank you, Mr. Lewin. Next, we have two questions also from Lewin. Since the establishment of ADR and mediation in IPOS in 2011, what are the statistics success rate achieved by IPOS? And do the ADR and mediation service refer to matters related to trademark, or they also involve various IP matters or issues? And also the second question is regarding the online mediation process. Is it cost effective and efficient in resolving the dispute between the parties?
Yeah, in the first question, I think in terms of the success rate, we are averaging, I think, less than right now. In 2011, we have what we call optional mediation. It's an option to the parties to go to the mediation, so they could opt out during the mediation. So we have a higher success rate. But in 2011, I think 2018, we implemented a mandatory mediation, which means that the parties must try mediation at least once. So when you look at the statistics, the success rates is much lower in terms of the mandatory mediation. But for cases, this involves opposition and cancellation of trademarks, and also involves, for IP matters, it also involves IP violation cases for patents, like infringement of patents, copyrights, also, and other IP matters. Then it also involves like for cancellation of patent rights. So it also some of the cases also involves that. If shifting to online proceedings, online mediation, I think we implemented online mediation as a precaution for the pandemic. So it doesn't cost additional. It doesn't provide additional cost to the party. So we're just implementing online mediation as a direct result of the pandemic. So I think in terms of settling the case, I think we see no difference with online mediation and face-to-face mediation, at least based on our experience. But some of the counsels that I have talked to would really prefer face-to-face mediation, because you would see the emotions, you would have a feel on the negotiation, what are being given by the emotions of the party. So I think some parties would prefer face-to-face, but in terms of online mediation, this is just the direct result of the present situation.
Yes, thank you, Louis. Yes, Alexandra, would you like to share anything?
Yes, I think it's very interesting now that we have to face these online mediations, also to know what my colleagues as mediators feel, because the parties may prefer sometimes the face-to-face. I actually have encountered parties who prefer online mediation, especially if they're overseas. They don't have to Alicante or to Brussels. And what we have seen as mediators is that all the preparation phase is much easier online. It's much more thorough than it would be in a one-day intermittent caucusing and single sessions. So it has advantages as that of the preparation. It has disadvantages. From my experiences, is that mediations are very much delayed in time. So maybe because of the fact that we can do everything via email before, I will give you an answer in 2 weeks. Okay, 2 weeks expire. Can I please have your answer? Oh, no, I'm sorry, because we haven't received an answer from our client yet. We'll get back to you. And I confess, I have a mediation going on for more than a year now. That started during COVID, and it is a very complicated case that has many issues. It is completely online. Right now, we do not foresee that there is going to be any kind of physical meeting. So obviously, now we know it. We know everything of the case almost, because we've been exploring so much. But it's being protracted, let's say, in time in comparison to how it would have taken place before. So I'm curious to hear what my colleagues think.
So Alexandra, I will go to Alicante anytime. It's such a beautiful place.
You will be very welcome. I'll be looking forward to that. Take your word.
Thank you. I think there are really very good advantages to online mediation, right? You talk about preparation. It's much easier to do that online. You can get people, like our pre-mediation, we did not have as extensive pre-mediation preparation when it was in person, but now it's online. It's like, wow, we can have 2-3 sessions of pre-mediation preparation before the actual mediation itself. So that's very good, because the better prepared you are in pre-mediation, the higher your success rate actual mediation. So that's one advantage of mediation, of online. The other advantage of online is that it's very easy to pull a document and put it on screen so that the other party is forced to look at it. I remember those days when it's in person, you distribute this paper and the other side is kind of like, ignoring it and all that. Once you put it on screen, everybody is forced to look at that document. And you say, did you not say in this document that you will pay me so much money? It's there, you can't escape, and the other side cannot escape. So in terms of document referencing, the use of documents, especially complex cases where you have reams of document, online is very effective because it forces party to look at that one document at the same time. There's no need to wait. The other thing that we found very useful is to get hold of the CEO, right? We talked about CEO being present, etc. So even if the CEO is not present at the mediation, it's very easy for us to say, okay, I'll give you half an hour to bring the CEO on. Whereas if it's in person, it's very, very hard. So again, access to higher authority is much easier. Having said that, I like in person because you can be in the same room and try to work it out. Whereas online, you have 3-4 hours and everybody's very tired. You have to move on to and when you have the second session, third session, you lose some momentum sometimes. And then you have to revisit the issues. I thought we agreed to that the last time, but they say, no, we didn't agree. Whereas when you have everyone in the same room, I mentioned my 26-hour mediation, you really push through, and there are advantages and disadvantages to both, but there is the advantage of, like Luin say, that personal touch when you are in the same room.
Yes, thank you very much, Mr. Chuan, Luin, and also Alessandra for sharing your answers and view regarding the online mediations. And from our side, we hope that one day we also have our workshop in person too, so that we can interact directly with all of our speakers. So dear our speakers and dear our colleagues, due to the limit of our workshop, we would like to close our Q&A session